The Presidential Election Petition Court is sitting for the sixth day, and top on its course list for Thursday is a pre-hearing session of the PDP and Atiku Abubakar petitions. The petitioners are returning to court 7 days after their case was adjourned to allow the parties resolve issues of document and motions related to the case. At around 9:08 a.m., the justices take their seat, ready for the business of the day. The justices are informed by the petitioner's counsel, Chris Uche, that they have settled key issues relating to the case and reached agreement on the documents to oppose. The respondents also confirm that all electoral documents that have been duly certified by INEC would not be opposed by them. The petitioners then proceed to move their motion, canvassing argument on why the court should allow live broadcast of the hearing. Uche argues that there is no statute that forbids live broadcast of presidential election petition court proceedings, submitting that election petitions are sui generis, which normal court rules on coverage does not necessarily apply. He contends further that the respondents will suffer no personal injury, neither have they disclosed any that they would suffer if the proceedings are broadcast live. In the application, the petitioners clarify that they are not asking the faces of the justices to be shown, but simply for the cameras to transmit the audio and visuals of the proceedings focusing on the courtroom. Among its 5 grounds is that the petition is of immense national interest. But the respondents are united in their objection to the request, asking the court to refuse it. Lead counsel for INEC, Abubakar Mahmood, argues that though the court is a public place, its accessibility to the public is through the journalist whose presence in court to cover the proceedings already satisfies the constitutional requirement for holding trials in public. Citing other jurisdictions like the United Kingdom, where live streaming of court proceedings was introduced recently, Mahmood submits that it is the court's technical facilities that control the live streaming and not the cameras of independent media organizations, and that allowing live cameras into the courtroom will defeat the solemn atmosphere which the courts are known for and turn it to a place of theatrics. Tinubu and his party, the APC, also push similar arguments, with Walo Lanikpekun submitting that the courtroom is not a crusade ground or a film house. He cites a provision in the Code of Conduct of Judicial Officers prohibiting broadcasting, televising, or photographing in the courtroom or areas immediately adjoining the court during sessions of court or between sessions. But the presiding justice, Haruna Sumani, notes that the citation is misleading, informing the lawyer that he is relying on an old version of the code, which had since been reviewed with a new version silent on the issue of broadcasting proceedings. Lead counsel for the APC, Lateef Fagbemi, in his submission, highlights the distinction between trial for the public and trial in public, which the law provides for. According to him, live broadcast of the proceedings as requested by the PDP is not what the law contemplates. He submits that granting the motion will open the floodgates for similar applications in other election tribunals across the country and also expose some of the witnesses whose identities ought to be protected. After hearing the parties, the court reserves its ruling.
Well, we are happy that our motion for televising of the proceedings has been taken today and ruling has been reserved. So that's a major accomplishment for today.
We have to wait for the outcome.
We have to wait for the outcome.
You won't ask that question
now. So don't go there.